Hello and welcome to today's live. Today we're going to be talking about how I improve my small business contracts in one pretty simple, easy lesson. Now, this is not all inclusive, and I know I say that repeatedly because there's so many different areas of law and there's so many different areas that you can work with when it comes to contracts. The last thing you want to do is consider that this is everything you need to know, because in the end, there's quite a bit more to know. We go through, for law school, we go to an entire year of contracts. So we get into the minutia of those contracts for good reason. This lesson is not meant for you to know everything there is to know about contracts. Heck, I don't know everything there is to know about contracts. Each contract I have to learn something and apply it and improve them and so on and so forth. So I don't want you to get the idea that this is the end all be all of everything, but this will make your contracts better than they were before. And that's the point. The point is I don't want you to be taken advantage of, or I don't want your business to fail simply because your contract sucked. And that's the truth. Like, I've seen some pretty horrific contracts, and we'll talk about those in just a second. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. Excited to have you. Please feel free to tune in every weekday, Monday through Friday at 11. And when we go live, you can ask questions, hang out, try to have a little bit of fun talking about the law. I know it's not the most exciting thing in the world, but I promise you to always bring value and always help you if you need it. So please tune in live. It would be great if you came. But if not, feel free to catch it on the replay. Totally get that. Sometimes you can't be available at 11. So let's get started. All right, so the very first thing that you're going to want to take a look at are your contracts. Do they have clear and definite terms, clear expectations of the parties? It doesn't have to be a crazy contract for it to protect you, but it does need to be very clear on what it's asking, the terms that it's asking, the performance that's required at certain points and intervals, how it's going to affect the outcome. What are considered material breaches versus an immaterial breach? A material breach goes to the heart of the deal. So if someone doesn't pay you money, that's a material breach. If someone misses a deadline and it's not a crucial deadline by a day, that's an immaterial breach for all intents and purposes. There's always different types of things, but you want to make sure that when you're writing, drafting, or talking about contracts, that you're clear on what is material and what is immaterial. Because, and here's the thing, what's important to you may not be important to the other person. Just how it is. So you want to make sure that the material portions are clearly defined in that of what would be most important for you. Be sure not to make them too onerous in that respect. Don't make them too complicated in that everything is material, because that's just not true. So when I look at a contract and people have made it so crazy that I just kind of shake my head at it. I looked at a wedding photographer contract a couple of years back now, and it was a really, like, you could tell the photographer drafted the contract because it had some really weird language in it that just wouldn't be seen in a contract drafted by an attorney. And the language was so, like, challenging. You could just tell that they were going to be difficult to work with, because your contract's kind of like, okay, so theoretically you should read every contract you look at, but I get that you may not. That being said, I don't want you to think that you can't, that somehow you have to have an attorney to look at a contract, but you should have an attorney look at a contract, especially when it talks about things that aren't clear to you as the buyer or seller or performer or that type of thing. So, but again, you want to make sure that it's clear what the terms are, what you're doing. The other reason why you want to make sure is that ambiguity is construed against the drafter, typically. Not always, there are some exceptions to that. But in other words, the more ambiguous you make it, the more it hurts you. I had a wedding photographer contract that I looked at. His contract was just really poor. And it was to fix it. Let's just say he thought by being vague, it would help him because then they couldn't hold him to it. But the reality is that when there's confusion like that, the courts hold it against the person that drafted it because you had the power to change it and be clear in your language. So he ended up paying about 3 times more than he should have on a breach of contract claim because I couldn't get him out of it with the language of the contract that it was in. And I mean, I did my best, but at the end of the day, if the contract is that poor or if it's written against you, then it's going to hurt you. That's just a reality. So I don't want you to think we can't do everything. And that's why it's so important that you get something in writing to begin with and that it's clear for those reasons, because you can't go back in time if there's a dispute. And that can cost you a serious amount of money. It would be really cheap, relatively speaking, to get a contract done to begin with, as opposed to the $6,000 that it cost him. But it was just a matter of his choices. And I get it, right? I mean, I really do understand that as a small business owner, contracts are one of those things where you think you can download a template off the internet and that it's going to be good enough. And the reality is it's not. A lot of times those aren't worth the paper that they're drafted on. All right, so let's keep moving. Your next thing that you're going to want to do is you're going to want to have a different contract for each type of relationship. So if there's a vendor that you use frequently, you want to have a specific contract for them with specific terms to them. If it's something else where you're the vendor to somebody, you want to make sure that it's a different relationship boundaries. Now, you might be sitting here going, well, yeah, duh, of course, that makes sense. But you'd be surprised how many people try to shoehorn, I don't know if you even know what a shoehorn is, but I digress. People try to shoehorn one contract into every type of thing. And it looks and is terrible. Like, it is bad. It is terrible for your business. It is terrible for you. So, you might have 4 different templates. There's nothing wrong with using templates, but modifying for each person, each particular relationship, have 4 different templates or 5 different, whatever number it is that you have, generally speaking, and make sure you're updating it regularly, that it's clear and consistent with the terms of the relationship. That's, again, comes back to this is making your contracts better. I want you to think of this as a type of insurance policy, okay? It's not an insurance policy. I'm saying it's a type of way of viewing it that protects both parties when there's a disagreement, okay? The other thing is if it's not in the contract, it doesn't exist. So if you think it's important enough to put it in the contract, make sure you put it in the contract. Make sure it's clear, okay? The next thing, make sure your contracts have choice of law and choice of forum clauses. These are very important. That's the beautiful thing about a contract. You can do so much with them. I love them. They're one of my favorite things, actually, because of what you can do with them. I want you to think about that for a second. Choice of law. So if you're located in California, you want California law typically. But if you have a multinational company, maybe you want to be Delaware law or Wyoming law or Texas law. It's up to you. Choice of law form is a great thing. The other part is venue. By choosing your venue, then it keeps things reasonable in costs to you, especially if you're a national business, because then they have to come to you as opposed to, and that's generally how it works, but it's all about placing, and there's some nuance to this, but it's clear to get it in writing. Like, for instance, instead of suing you in one court, you can have it specific that they have to sue you in, like, for instance, San Diego court, so that it's easier for you to manage. And you can do this through the contract. That's one of the benefits of having a contract. This is one of those clauses that I see get left out of contracts that are drafted by people as opposed to contracts that are drafted by attorneys. I don't know why they don't think of it. A lot of them just download the boilerplate contracts from the internet And so the boilerplate contracts don't always have these in them, and it's not good. So the next thing that you're going to want to have is a dispute resolution clause. Now, there are lots of options on this one, and this is one of the great ways to be proactive about issues that may arise. So, for instance, you can choose litigation straight up. Say, you know what, we're just going to do litigation. You can choose to say we have to mediate it first, and then we can go to litigation if we can't figure out the dispute on the mediation. Okay, that's one thing. You can also do mediation, then arbitration, and then litigation. Now, they all have their pros and cons to why they're good or bad or whatnot. And so by doing this, though, you're maintaining control of that relationship, of that contract. If you don't, then it's basically whatever the law is in your area. Think of it this way. There are certain laws that are what are called default rules and certain laws that are mandatory rules. And so a lot of these things, by making choices, you're changing the default from whatever the standard is in your area. And so it gives you a lot of freedom. That's the point of this. It's not about giving. It's about making a dispute less painful for you. So that's alternative dispute resolution or litigation. And now all of these clauses should be discussed with people. You should discuss them with an attorney. Not suggesting you have to hire me or anyone for that matter, but ideally you want to at least sit down and say, hey, can you review this? And it'll cost you a little bit, but I promise you, in law, an ounce of prevention is worth a pound of cure. So please keep that in mind, that you shouldn't look at it as, oh my gosh, I have to pay the legal fees, blah, blah. I hate that. You should look at it as, I get to pay the legal fees because I'd rather spend that money on this than spending it on absurd amounts of litigation or a potential settlement that costs you thousands of dollars, right? So a bad contract, literally, and in the comments, I can tell you this, can ruin a business, because I've found that people with bad contracts tend to get sued more often than people that have good contracts. That's just how it works, because a good contract keeps people from suing you. That's just the truth. That's just the truth. Next, one of the clauses that you're going to want to decide, and this is best decided with an attorney, but is an attorney's fees clause. Some states, again, this is state specific, so you need to make sure that you're clear on this and that you're consulting a local counsel. But attorney's fees, you can contract to say the prevailing party gets attorney's fees. Okay, that's a very simplified version of what would go in the contract. And what that does is it helps settle things. It motivates the party that might be in the wrong to not risk going to litigation or mediation, arbitration, whatever, because if they lose, then they lose their the attorney's fees as well. And that can be really expensive, like insanely expensive. So you got to keep that type of thing in mind. So I'm not saying which one's right or which one's wrong, but you want to make sure that that's in there, because it can be hurtful if you don't clarify. Because the default rule, at least California-wise, is that in California, you only get attorney's fees if there's a statute for it or if there's a contract for it. Other than that, everybody pays their own. And you can contract to say that everybody pays their own, which will change the litigation matrix of the case. So that's the number 5 is attorney's fees. Number 6, and these are miscellaneous clauses. These don't really make or break you, but they do make your life easier. They do make it so that you've got more to work with. So number 1, you have what's called a waiver clause. If you waive a certain provision, it doesn't waive the entire contract. Something I like to put in all of mine so that they can't say, well, you did this, so the whole contract's void. No, waiver clause is great for protecting the person who drafted the contract. Severability, this goes to whether or not If a provision is found bad by a court, then it doesn't invalidate the rest of the contract. And that's a bigger issue for a different thing. And then one thing that I absolutely wholeheartedly cannot stress, recommend enough, is what's called the modification clause. And this makes it so that you can't modify it unless it's in writing, signed by both parties, so there's no misunderstanding about what's clear, and that someone can't say, well, you said, or you wrote this email, and this just creates a more complete, more accurate contract, because then they can't use the outside terms to dictate what happened in it. So anyway, those are the top 6. I mean, I know there was a few fudges in there, but these are all things that you need to consider. And, you can technically download them from the internet, but I would strongly recommend not. And for a lot of things, because you don't know what you don't know. These are just highlights. This isn't the end all be all. This isn't everything about it. This is what it is. So think about these things. Consult an attorney in your local area. If you have any questions, feel free to reach out to me. Don't forget, I go live Monday through Friday at 11 a.m. and stop by. I'd love to talk with you. Have a good one.